Hi, I'm Anna Denton-Jones from Refreshing Law Limited, and as well as being an employment law solicitor, I'm also a trained mediator. In this session, I'm going to be looking at mediation from an employer's perspective. There is a separate video that I've made looking at things from an employee's perspective, and it certainly might be worth your while watching that to understand more about what mediation is and how it works. From an employer's perspective, I think it's very important that employers offer mediation with a very open mind, if you like. They shouldn't be trying to enforce a particular outcome on the parties. Indeed, mediation is only going to be suitable in a scenario where the parties have got the ability to control the outcome. So, for example, it wouldn't be appropriate to use mediation in a situation where, the parties might look to agree one thing, but then they're going to have to get, approval from somewhere else for it. It needs to be, for example, a conflict about the behaviours towards each other. Obviously, those two individuals have the capability then to agree how they're going to behave towards each other going forward. It's not suitable to use mediation in a situation where the employer's got a fixed view of the outcome or is seeking to impose a particular outcome. That's simply not going to work. Equally, it's important to not try and manage performance or conduct and things like that by the back door using mediation. If you were to do that, it might actually undermine the line manager's role. Ultimately, the line manager has to be able to do their job and to manage. Certainly, I wouldn't recommend mediation in any situation where somebody is perhaps unwell, and actually putting them through the process could make things worse. So sometimes we need to establish that somebody's actually fit to take part in the process. But certainly, mediation can be a very useful tool to get parties to start talking to each other and looking at restoring the working relationship. Perhaps where we're at the early stages of that relationship breaking down. And it can be a useful mechanism to come up with solutions that perhaps aren't available via other means. For example, one person voluntarily apologising to another in a circumstance where they're not going to feel that it's been imposed on them as some kind of order that you must apologise to the other person, because that's always going to ring hollow and not be felt to be genuine. Certainly, I think it's important to deal with conflict at an early stage before things have become too entrenched. If parties have been in dispute for many, many years and there's layer upon layer of sort of grudge against each other, then mediation may well be too late. It may be too late to change their minds and their view of each other. So it is important to try and nip things in the bud at an early stage, perhaps when the first signs of conflict are there, rather than perhaps a last-ditch attempt to restore the working relationship. Can be done in groups. You've got to be very careful if there is a large group of employees involved, obviously, to not put anybody in a position where there's a sort of ganging up on the others. But certainly I've worked in situations where you might break down a group into smaller chunks and perhaps have sort of mini mediations with pairs within that group, or certainly worked in situations where a number of mediators are involved, again, to try and break things down into sort of workable bite-sized chunks. So don't discount it if there are more than one person or two people involved in a particular situation. If you've got any more questions about when a situation might be suitable for mediation, please do contact me. It's adenton@refreshinglawltd.co.uk. Thanks.